So with that, we are going to bring in Duane Fouts, as I mentioned at the beginning of the hour, or at the top of the hour. Last minute, we had our scheduled guest, fall ill last night. And so, Duane, I appreciate you stepping in and making the time for us. And as I'd mentioned, I have no idea what we're talking about. So
we'll just wing it, man. So, right. I get the text this morning about a little after 7 o'clock from Nick saying, hey, we need somebody to fill in for our guest who's ill this morning. And can you talk on something on real estate for a half hour? Suppose I could do that?
Maybe.
So sure, I'm happy to do that. So
don't look at me to lead this conversation. I got nothing.
So there's lots of things I can talk about, but one of the things that I think is going to be very instructional and something that came across my desk in the last week or maybe 10 days ago, something like that, and it has to do with non-refundable earnest money. So let me ask you this: is there ever a time when non-refundable earnest money is not refundable, or I said be refundable?
Yes.
Yeah.
Couple of them.
Yeah, I would say yes. Yeah. Absolutely. Yeah.
There are. And so I'm going to go down this road of this transaction and kind of lay it out for you and give the how an agent can inadvertently get into a situation that creates some problems for their client, right? So in this case, we had the seller, right? We were the listing broker. The property had been on the market. We're going to go back to the May, June timeframe. Market was still pretty good. We had lots of sellers were still driving the bus, for example. This offer comes in from a cooperative agent. Offer has it's a full price offer. Has a lot of favorable terms, shall we say? And I'll just read you what the buyer put into their contract. On page 8. It says buyer's earnest money to be immediately released to seller on completion of buyer's due diligence and acceptance of the buyer inspection notice by seller. Okay, you with me so far?
So far.
Yeah.
So far. We also have a buyer contingency that says that the contract is contingent upon the buyer selling their home, right? Within a certain period of time. In this case, it was by June 6th. They had to have their home under contract. We're all familiar with the standard language for the buyer contingency, right?
Right.
So, fast forward, seller accepts the contract. There's a $5,000 earnest deposit. Earnest deposit is placed as normal with the escrow company. Okay? Still with me?
Yep.
All right. So, 2 weeks go by. We're now towards the end of May. The buyer still hasn't listed their property for sale. Is that a problem?
Yeah.
Yeah.
How do we fix it?
They haven't listed the home.
The buyer has not listed their home. They're now still a week away from when they have to have their home.
I would say we would first of all cure them.
Okay. On what?
On the grounds that they haven't listed their home.
Where was that written in the boilerplate of the contract?
I thought that was in the contingency addendum.
Nope.
It's not there.
Oh, I thought you said it was.
Not in the contingency addendum.
The language is in the contingency addendum doesn't say anything about when the buyer has to put their home on the market. And obviously the anticipation is if this contract is accepted, buyer will immediately put their home on the market and immediately sell it, right?
Yep.
In this case, that didn't happen. They put their home on the market the last couple of days of May. So they waited about 2 weeks to do that. June 6th rolls around, which is the date on the buyer contingency. And the buyer still hasn't had a contract on their home, not even an offer. So remember the language I read to you on page 8?
Mm-hmm.
Yep.
It said what? The escrow company is to release the earnest money, $5,000 to the seller.
Due diligence period.
After the due diligence period.
Which has absolutely nothing to do with the contingency.
Has nothing to do with the contingency. So this escrow, the due diligence period during this period of time was was flowing, right? The buyer accepted the property, no repairs requested. As you remember, that's how a lot of buyers were doing it back in that time frame. And so what's the escrow company do? They're going to release the earnest money to the seller, right?
Right.
What conversation do you suppose the listing agent is having with the seller about this money, this earnest money? It's non-refundable, right? You're not going to get it back. The seller's not going to have to give it back to the buyer. So fast forward, June 6th comes, buyer doesn't have their home under contract. Now what happens?
The buyer asks for their earnest money back and wants to cancel the contract.
Well, what's the buyer contingency say about the sale of a home? If the buyer doesn't have their home under contract, automatically the contract cancels, right? And escrow issues a letter saying escrow's canceled. You're free to go and sell the home to somebody else. Buyer does not make a demand for their earnest money at that time. Okay. And about, let's say about a month later, escrow gets an email from the buyer's attorney. Not just any attorney, it's one of the prominent law firms in town. And let me read this to you. And I won't give names, so I'll just use buyer and seller. Buyer has provided me with the contract and addenda to the contract. Buyer and seller entered into a standard AAR residential contract on such and such a property. Pursuant to the contract, $5,000 in earnest money was deposited with the escrow company. They also buyer and seller also entered into a buyer contingency addendum. On line 5 through 11 of the buyer contingency addendum, it is clear that the contract pursuant to which the $5,000 earnest deposit was made, it was contingent upon the buyer accepting an offer for the sale of their property located at on or before June 6, 2022. You know where we're going?
Yep.
Despite the fact that the buyer's property on such and such address was continuously listed, which, by the way, it wasn't continuously listed, for sale with a licensed real estate agent, no offers were made by prospective buyers. Since there was no offers on the property, there was no offer that could be accepted by the buyer. Since there was no offer made and thus no offer accepted, the contingency to the contract failed. Since the contingency to the contract never occurred, the contract was not enforceable. See Sam Levitt's Furniture versus Safeway from 1970. It's a lawsuit cited. Since there was an unmet contingency, the contract never became operative. None of the remedies in Section 7 of the contract could become operative because the contingency failed. There could be no breach because the contract failed. There could be no cure because there could be no breach. What do you think the chances are that most agents would have advised their client that earnest money was going to be totally non-refundable?
I think most would.
Yeah, I think most would. Yeah, absolutely. Yeah. I probably would, but I would have though. I mean, it's me. I would have had this conversation with you or one of your staff. You know, because anytime we go into these non-refundable things, I'm always picking up the phone and calling you guys.
Yes, and I appreciate that, but it's an easy one to overlook. You know, because you have to understand what a contingency really is, and a contingency is all about its precedent to having an enforceable contract.
Can't go forward until that contingency has been met.
Correct.
Yep.
And so did the escrow company do the right thing by releasing the earnest money?
Well, if they followed their potential contract, however, maybe they aren't attorneys either, so they didn't read all the terms and conditions before releasing it. But
well, they had a copy of all the documents.
They could have. Yeah.
Yeah.
Maybe should have.
So anyway,
So these kind of, so to your point here though, you have a contingency document. That's a slap in the face because it's away from the boilerplate of the 10-page contract. However, in the 10-page contract, there's something that's also like this, not to get away from the point you're going to ultimately make, but to try to help drive it home. There's an FHA VA mandatory clause that could be on an FHA loan, so you get an FHA loan.
Oh, yeah.
And then that same contract says the same verbiage, or maybe not the same verbiage, but somewhere along the line it says the earnest money shall become non-refundable at the end of the inspection period, right? And so all of a sudden, but yet that FHA VA mandatory clause steps in, and that's even signed after, some could argue.
Most times.
But the point that is the earnest money would still be released back to the buyer because you can't trump a federal law.
Yeah.
Well, I want to get into that because I do think that's a whole.
We'll talk about that when we finish this one.
Yeah, because I've got some questions on that one.
Yeah. So anyway, the escrow company responds back on this and says, well, pursuant to Section 8 of the purchase contract, the escrow company is directed to immediately release the earnest money to the seller after completion of the due diligence period with the acceptance of the buyer. The buyer accepted the subject property without request of any repairs on such and such a date. The earnest money was released to the seller on such and such a date. Any demand for return of earnest money should be directed to the seller. Seller's real estate agent. Information is on page 10 of the real estate purchase contract. So this is the attorney for the escrow company replying back to the demand from the buyer's attorney. So at this point, the attorney responds back to the escrow company's attorney and says, Section 8 of the purchase contract is contingent, as was the remainder of the purchase contract, on the fulfillment of the buyer contingency addendum. Line 7 of the buyer contingency addendum states that the purchase contract was contingent upon the buyer accepting an offer to purchase her property. The contingency failed, which means the purchase contract, including Section 8, failed. It never became operative. The title company had an obligation to release the escrow funds back to the buyer. The title company had no authority to give the seller escrow money. I renew my demand that the title company send a check payable to the buyer by the end of the month. So here we got two attorneys arguing, which is common in these kind of situations, right? As to what is the proper thing. Fast forward a little farther until about September. The seller gets a process server knocking on the door.
Mm-hmm.
The buyer had decided rather than file suit over the $5,000 in justice court, they filed suit in small claims court for $3,500. That's the maximum limit. Yeah. That's the maximum limit. There's no attorneys involved at that point. It's just buyer and seller. As they couldn't use the alternative dispute resolution process of the contract because they were arguing that there was no contract when that contingency failed. And so they went directly to small claims court. And in this case, unfortunately, the small claims court ruled in favor of the seller, and in favor of the buyer.
Okay, that's a big deal right there.
Yeah. It is a little bit of a deal. So they ruled in favor of the buyer, and the seller ended up having to write a check for $3,500 back to the buyer. And I can see when this all came across my desk, I could see how an agent could inadvertently get into this with that non-refundable earnest money. And we've seen the reason I wanted to talk about this is because it can happen so easy when you don't understand what those contingencies actually mean. And anytime you have those contingencies, those are things that are precedent to that contract becoming enforceable. And so how do you protect your client if you're on the seller side? You got to have that all those contingencies are deemed fulfilled and met at the time that money becomes non-refundable. I know our standard language in our additional clause addendum doesn't say that. There's a few contingencies in there that are not addressed, and there are potential contingencies that are not addressed in that language. And so if you're dealing with that kind of a scenario, please reach out to us as brokers so we can help you make sure that all of those are covered and the intent of your client is protected.
So the first couple of things that pop up to my mind, and you may not even know the answer to question number one. Did the title company, and I know the answer to the question, but I think as agents, we all need to know the answer to the question. One, did the title company receive the loan or the contingency?
Yes, they did.
Okay,
The buyer contingency.
The buyer
yes.
contingency,
Yes.
and it's important that we submit all of that stuff
Correct.
to the title
To the
company
escrow.
because it is part of the contract.
To the escrow company.
Okay, so
Yep.
then second, I mean, it didn't sound like that attorney went after our agent.
Nope.
Do we have any liability in this situation?
Well,
I mean, obviously, the listing, our seller could go after us
From the seller,
Mhm.
right?
but not any liability from the buyer going after
correct.
us.
The buyer was represented by a broker from a cooperating company, so there would be, in my opinion, no exposure from the buyer perspective. Do we have from the seller perspective? One of the questions that's being asked is, what could we have done differently
Mhm.
as the representative of that seller to protect their interest? That gives me some heartburn because both the standard ADRE statutes require that we promote and protect our client's best interest. Also, the Code of Ethics requires we protect and promote our client's interest. And if you really want to nitpick at this thing, we probably fell a little bit below what would be expected of a representative because we didn't advise that there are contingencies that, in certain circumstances, could allow that money to be refundable.
And there was more than just that one.
Yeah. Oh, yeah. This is just one that went through the whole process, right?
Well, I'm just saying to that same point, the same language on the same contract. There were other things in that contract, unfulfilled loan contingencies potentially, because there's no language, there's no.
That's in the additional clause.
Additional clause, right?
That language is there.
Yeah. So, I mean, all those different things, but again, people sometimes don't use those. They don't refer back.
And I think one of the takeaways from this is understand what your language is saying.
Absolutely.
And if you look at the language that was put on that page 8, it says buyer's earnest money to be immediately released to seller upon completion of the due diligence. That doesn't mean non-refundable.
Correct.
That just says the seller's going to hold it now.
Yeah.
The only non-refundable part was on the additional clause addendum, and that didn't address the contingencies out there. So yeah, I mean, and these kind of things, they don't happen very often. But you sit in my seat, you see them more often than you'd like, right? But you as a practitioner sitting out there every day, you don't see these type of things. And so understand that when your things are a little different than what you want to confirm things, reach out to us because we see them quite often.
Yeah, I take the position when I start to see non-refundable earnest money, whether I'm on the buy side or on the listing side, of there are, in my opinion, and I'm definitely not a broker, there are very, very few incidences, I think, that occur where earnest money truly is non-refundable. There is always a case to be made, and I think a lot of agents don't understand. Yeah, you can go through the due diligence, you can go through the inspection process, you can go through all that, and then all that buyer needs is a loan denial letter from the lender without that doesn't even have to have an explanation of why they are getting denied. And I explained to all my sellers in those situations, it's going to be very hard to keep that earnest money. Not saying impossible, but I let them know from the beginning, it's going to be very, very difficult. So have a clear explanation with your seller of what earnest money is.
Thank you for having that conversation. And I wish that all of our licensed agents would do that, have that similar conversation when it comes to earnest money. Our contracts are very buyer friendly.
Very.
And for an agent to opine to their client on the listing side that money is going to be forfeited, it's just problematic.
Yeah.
Can it be? Yeah, it can. But it's when you as an agent say you won't have to, that money is going to be forfeited, there are too many arguments to be made.
Let me ask you this: as far as the 3 day, the buyer
notice?
No, the buyer needs to get 3 days prior to get the CD.
Yeah.
Okay.
Mm-hmm.
once they once the and this is a question I have. So once that CD is issued
Mhm.
and a buyer has signed it,
Mhm.
within those 3 days, or let's say 3 hours prior to, can the lender then issue a loan denial and the buyer can retain the earnest money?
Can they?
Well,
Probably.
okay.
Yeah, they probably can. I can tell you that I have had one case in my career where loan was funded to the escrow company. All parties had signed, just waiting to record, and the lender's underwriting team finally came to the conclusion that the buyer had committed fraud on their application, and they pulled the funding back. So we were this close to recording, and they came to a conclusion and they pulled it back. So yes, things like that happen rarely, but they do happen.
I think Mike and Duane, the best answer for realtors, and I like to look at these things as what I call contract red flags. Like,
Mhm.
you're walking through a property on an inspection, you're supposed to, or on a tour, you're supposed to identify red flags. That's a realtor's responsibility. Not know beyond that, but just identify those red flags. Well, if we take that same precaution into the terms and conditions of the contract, and anytime we receive something that says non-refundable, or even the word waive SPDS, waive inspection period, waive appraisal, whatever those things are, those potentially are, could end up in a violation of your fiduciary duty to your client. So the smartest perspective is to say to the consumer, so Duane, in Mike's case, what he just said, you can't interpret the language. You can in your boilerplate to a degree, but if the consumer's concerned with any of these things, the proper answer is always, please contact a real estate attorney to learn what what liabilities and responsibilities have changed if you desire to waive that, or if you desire to accept a non-refundable earnest money, because at least at that point you've got you're not playing attorney.
Yeah, and you're actually shifting some of that responsibility and liability away from you and your firm. So
Well, I
yeah.
want to get into, because we only got about 5 minutes left. I do want to get into the FHA mandatory clause,
Mhm.
and so because I used to look at it differently, and I got corrected, by my broker. My interpretations was not spot on. So my interpretation was that that once you go past, well, first of all, I used to think that that if they waived earnest money or they made earnest money non-refundable,
Mhm.
despite inspection, and we still did the inspection, uh, that earnest money can be lost if we waive our inspection period. But it's
Mm.
where you're not waiving your right to get your earnest money back. Even if you release earnest money and make it non-refundable, the FHA buyer still has to get qualified at the end of the day. And if you go past the inspection period and then day 5 days prior to close of escrow, that FHA buyer now all of a sudden does not get qualified and gets denied the loan, they're getting that earnest money back,
Correct. Yeah.
despite whether you say earnest money is non-refundable.
Well,
Am I right?
so the FHA and VA mandatory clause deals with appraisal issues only. Okay. And so a VA or an FHA buyer cannot be penalized by forfeiture of earnest money due to a low appraisal.
Okay.
Okay. So can a FHA or VA buyer waive or forfeit earnest money for other reasons in a contract? Sure, they could, but they cannot be penalized by forfeiture for a low appraisal. Okay, so in those cases, if that FHA mandatory clause is not um, signed until later in the deal, it's still going to be applicable because there's a federal law that revolves around that. So, yeah.
Okay, so yeah, so I misspoke. So the kind of what the case that I was making was when I was representing buyers, saying, "Hey, listen, that's okay. Make earnest money." And this was years ago, but we can make earnest money go hard, non-refundable, whatever the case is. But at the end of the day, if you get denied the loan, you're going to get your earnest money back, and that's
No.
not necessarily 100% the case.
That's
and
correct.
That's where I had. That's where I
correct.
was in error.
Because it depends on what language you're using for that non-refundable earnest money, and then if you use a standard additional clause addendum, that specifically says that you will not get your money back if you get denied a loan. So, among other things.
All right, so let me throw it. Oh, go ahead.
I'm sorry. I just want to make sure people are hearing the word rejected for the loan, denied for the loan. You can be approved for the loan. You can be approved and yet still issue an unfulfilled loan contingency if the loan that you were approved for is different than the loan you told the buyer and seller agreed to on the AAR pre-qual form.
Correct.
And so as a result, you could be approved, but say you wanted to put 5% down, as Matt was talking about earlier, and because of whatever credit reasons you got approved, but with 10% down, that's not the original loan you requested. So you can still, even though you were approved at 10% down, you can still use the unfulfilled loan contingency and get your earnest money back. Or potentially get your earnest money back.
And because like I said earlier, the lender does not have to provide the reason why they're issuing. All right, so we got 3 minutes. So I got this is a situation. All right, so I represent the seller. Okay, we are having insurance issues with the HOA. Everybody's aware of this. Okay, to protect my buyer, even though we knew.
I thought you represented the seller.
I represent the seller. I did represent the seller. Thank you. See, we're both, so I represent the seller in this. But knowing that we're probably not going to get an answer, a resolution from the HOA and the insurance for 2 weeks out, I went ahead, though, and issued the 3-day cure notice just to protect my seller so that at any given time, we can cancel the contract, or we find out verbally that the HOA is not going to be able to take care of the insurance process. We've now got the 3-day cure notice enforced. 3 days have gone. Now, at that point, let's just say hypothetically, we go ahead and cancel because they have not fulfilled, they have not closed within those 3 days. Could we retain the earnest money?
Well, there's a lot of depends in there, but with regard to a breach,
asking for a friend.
I get that. With regard to a breach, if the cure notice was drafted appropriately for what the reason was for the buyer's potential breach,
failure to close
escrow, 3 days elapsed, and the buyer still has not closed, and the seller theirself is not in breach of the contract, then the seller could make a demand for cancellation.
Yeah.
There's another step in there. The seller has to make a demand for the cancellation and forfeiture of earnest money. But there's a lot of what ifs in there.
Yeah, I would say in that situation, I think the buyer can make the case that the HOA did not have the right insurance policy in place
for their loan.
All right. All right. Duane, thank you again for stepping in. Good
wait
stuff.
a minute. I got a bunch of more stuff to go here.
I know. That was fun, though.
Okay.
All right. Appreciate you joining us today. We are out of time, but leave you with the quote of the day. Fear kills more dreams than failure will ever will. Appreciate everybody joining us today. Go out and sell a home.